December session, the Court of Common Pleas in for Hamilton County is now in session. The Honorable Leslie is presiding. Please be seated and remain quiet.
Good morning, ladies and gentlemen. Can you hear me? Everybody can hear me? Okay. We're set today pursuant to Superintendent's Rule 12 and 45 for a hearing on two distinct matters. The first is the issue of media access to the courtroom, and the second is whether completed juror questionnaires will be released to the media outlets and members of the public who have requested them. I don't think I'm saying anything that people do not know, but this is an unusually high-profile case. It's a rare police use of force case caught on camera, and it has resulted in law enforcement and a law enforcement official charged with murder. This matter has garnered national media attention. A simple Google search of the sentencing trial results and many headlines regarding the jury. Social media is similarly full of discussions of this trial. The first trial ended in a hung jury, and the court decided at this point it needs to take judicial notice of the following facts. Number one, there were prior proceedings in this case during its first trial, including a hearing with the news media. Second, during that first trial, jurors expressed great concern for their safety and the safety of their families. Third, many recent news articles have been published surrounding this case. I don't think that's a shock to anybody sitting in this room today. For instance, the headlines in the majority of the papers today, I shouldn't say papers, but media outlets today, is about what is happening this morning. We had another one over the weekend that was a headline, and it was actually the front page of the Cincinnati Enquirer regarding evidence that was inadmissible at trial. We've also had, just in the last few days, we've had a number of cases in the headlines. Tensing trial and a holding pattern over the media access, which was on WXIX on May 30th this year. Appeals court blocks tensing trial judges' restrictions. That was on Cincinnati, in the Cincinnati Enquirer on May 26th of this year. And start of jury selection in the Ray tensing trial gets contentious and confusing, and that was WLWT on May 25th. Of course, that's just a sampling. There are hundreds of these out there at this time. The fourth thing that I'm taking judicial notice of is that prospective jurors in this case have expressed concern over their privacy and safety after hearing that their identities may be made public. I want to make it clear to everyone that I did an in-camera review of all 180 juror questionnaires that were filled out by the jurors who were able to remain after our initial meeting with them on May 18th, or I'm sorry, May 25th. And in that in-camera review, there were two particular questions that relate to the media publicity. Question number 4 and question number 150. Question number 104, I apologize, and question number 150. Out of that, there were, out of those 180, there were 77 responses who either don't want to serve if their identities are revealed or their information is released to the media, or have a safety concern. 38 of that 77 are not willing to serve if their identities are released to the media or if there's media attention to them, and 39 of those are afraid for their safety. 22 of the respondents said yes to both of those things. That is a significant amount of our jury pool. That's quite a few people. And fifth, during the previous hearing held in this case, and that was last Friday, we had a hearing, cell phones in the courtroom created a significant distraction. You were all here. There was a phone that was dropped onto the bench in the back that distracted. We had expert witnesses on the bench, giving testimony at the time. And the second was over here in the jury box. Someone's cell phone went off, and it's actually me saying in the record, "You've got to be kidding me. I thought it was a fire drill," because of the type of ring it was. Everybody kind of looked around. The reporter scrambled to turn off the phone. Jury intimidation and tampering. Oh, I apologize. I do want to note local Rule 30, which governs filming, videotaping, recording, or taking photographs of jurors. And this shall not be permitted in any circumstance, and it is so ordered by this court. Violations of this rule will result in a finding of contempt, and you personally or your station will be fined for that. Jury intimidation, tampering, and the need for a fair trial are all reasonable concerns and all weigh heavily on the mind of this court. In January of 2016, I presided in a case where the defendant was able to acquire the names of all the jurors in his trial and thereafter stalk their respective profiles on social media. It ended up that the person he sent to do this was ultimately prosecuted for it, but the point is jury tampering occurred in my own room when I was allowing media devices, or I'm sorry, not media devices, but electronic devices of any kind into the courtroom. The internet and the social media make it much easier for jurors to be found and to suffer potential harm as a result of the decisions they make in this trial. Further, unfettered news media access in the courtroom creates the potential risk of distraction to the trial participants, including the jurors. Pursuant to Superintendent's Rule 12 and pursuant to this court's inherent authority and discretion to regulate procedure in the courtroom so a fair trial and justice may be achieved, the court will now hear evidence concerning this issue, whether or not permitting broadcasting and or internet streaming of this trial may, in the words of the Ohio Supreme Court in the State ex rel. Grinwell Communications versus Love, would 1, distract participants, 2, impair the dignity of the proceedings, or 3, otherwise materially interfere with the achievement of a fair trial or hearing. If any of those elements is proved by clear and convincing evidence, then this court will exclude or limit broadcasting and internet streaming of this trial. Pursuant to Superintendent Rule 45E1 and 2, and pursuant to this court's inherent authority and sound discretion to regulate procedure in the courtroom so a fair trial and justice may be achieved, the court shall also hear evidence concerning this issue. The presumption of allowing public access to completed jury questionnaires if it is outweighed by a higher interest after considering each of the following: whether public policy is served by restricting public access, whether any state, federal, or common law exempts the document or information from public access, and whether factors that support restriction of public access exist, including a risk of injury to persons, individual privacy rights and interests, proprietary business information, public safety, and fairness to the adjudicatory process. At this point, I'm going to allow evidence to be presented. The attorneys who will be introducing evidence and call and question witnesses are the court's own counsel, Mr. Mark Landis, and attorneys for the news media organizations represented today, Mr. Jack Reiner and Ms. Monica Diaz. At this time, Mr. Landis, I'll give you the floor.
Your Honor.
Yes.
A couple of threshold points I'd like to raise with you. First of all, we object to the presence of Mr. Landis, and we object to his purported representation. We do not believe that revised code 30514 was satisfied. We've not seen any evidence of an application of the prosecuting attorney and board of county commissioners that authorizes the employment of legal counsel in this matter. If that exists, we'd like to see it. If it does not exist, I don't believe Mr. Landis is authorized to continue in any representation role. And again, I apologize for just bringing this up, but I just found out about 30 minutes ago that Mr. Landis was employed. I did not see, even yesterday, any appearance of counsel. I've not seen any application. I've not seen any approval of his employment. Your Honor, I think we are all really on the same side here. We want to do the right thing, and we want to do it the right way. So unless 30514 was followed, I do not believe Mr. Landis has authority to proceed in his role as counsel.
Yes,
Your Honor,
Ms. Diaz.
Monica Diaz, representing Scripps Media Inc., WCPO. We object as well to Mr. Landis' role in these proceedings.
Okay, I will just make the assumption that if one of you is objecting, it's a standing objection for both of you, unless you both want to stand up and make your appearance known. Otherwise, it'll save time and effort if you both want standing up. I mean, I recognize you're both on the same page.
Thank you, Your Honor.
He is permitted to be here. Your objection is noted for the record, and you will go ahead and begin. Thank you, Mr.
I
Landis.
have two more.
Oh, go ahead.
Okay, thank you, Your Honor, I appreciate it. Your Honor, I know that you vacated the May 18th order. There is, however, an entry that was entered on May 24th that is and I think there's about 108 of them, that are entries approving the applications of the various media to be here.
Right.
And in those entries, there's a provision forbidding the photography, videography, or broadcasting of jurors. There's also prohibition on photographing or videotaping or broadcasting witnesses or victims who object. Does that order remain in place as of right now?
It does not, obviously, because I don't believe anybody here signed one this morning. If they did, I'm not aware of it. But as of this moment, no, they are not in effect either. We will address that in the order that will follow today.
And then one more thing, Your Honor, I just want to get this so that we understand. At the May 18th hearing, at page 29 of the transcript, beginning at line 11, you made the admonition from the bench. I also want to make clear to the media and to the attorneys for the media that I am not and will not be discussing or even entertaining any request to release juror identities or completed or redacted jury questionnaires until the trial is concluded. And that is because of the distraction that I have taken judicial notice of already from the prior trial. It is not going to be entertained, so please don't waste your time filing something with me asking for that information. Does that admonition remain in place, Your Honor, or have you withdrawn that admonition?
It's withdrawn at this time, but I'm just curious, did you hear anything I just said? I did say all of that will be addressed today. That's the point of this hearing. Anything prior to today is off the table for the time being, and that's what this evidentiary hearing is for. That's why I went through all of this earlier, and one of the things specifically I said that will be addressed is are the juror questionnaires. There is a pending request from WCPO for unredacted jury questionnaires currently.
Thank you, Your Honor. Is the court's response to my question about Mr. Landis, though, that the requirements of 305.14 have been followed?
Yes, they have.
Could we see the application?
You'll have to go through the proper channels to get that. I'm not going to walk out and hand you what you get through the prosecutor's office. Okay, can we move on? You can note your objection. It's noted.
Well, Your Honor,
right?
the only reason that is causing a problem is that it was revealed to us 30 minutes ago.
Well,
so I think it would be appropriate to enter into the record, based on our objection, that he has been hired properly pursuant to the statute.
He has been, Mr. Landis, would you like to speak to that?
The difficulty here is, Your Honor, is that this process is neither up to you nor I, but rather to the prosecuting attorney's office and to the presiding judge. And so counsel is asking about something for which you and I are not directly responsible. I can tell you and represent to the court that Jim Harper from the prosecuting attorney's office sought me out this morning to assure me that I was retained for the purpose of providing legal assistance to the court in its efforts to determine the very issue that we're about today. Mr. Harper is a respected member of our community, and I trust his word, and I'm here to work.
Okay, thank you, Mr. Landis.
Thank you.
Your objection is noted for the record. When you're ready, Mr. Landis.
Thank you. We call Tim Noel. Hi, Tim. Good to see you. Would you please come up and take the witness box and give the oath?
You do solemnly swear that the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Probably use a nail, like right down the middle of that would be helpful. Would you state your name, please?
Timothy Knoll, last name spelled N-O-E-L.
What's your position in the courthouse?
I'm a bailiff for Judge Megan Shanahan.
How long have you been doing that?
I've been a bailiff for almost 6 years.
You have in front of you a white binder. For the record, I've handed the same binder to the court, to the media counsel who are at the counsel table and to a representative of both the prosecution and the defense in State versus Tensing. I ask you to turn to Exhibit B, that's under a tab conveniently marked B, and ask you if you recognize what's there.
Yes, it's my affidavit from the previous trial.
Is your signature on that?
Yes, it is.
Is it notarized?
Yes, November 2nd of 2016.
And who notarized that for you?
You did.
Have you looked over that Exhibit B recently?
Yes, I have.
As your memory sits today, are those statements in the affidavit true and accurate?
Yes.
This concludes my examination of this witness, Your Honor.
Okay, thank you, Mr. Landis. Mr. Greiner, any questions on cross?
Well, Your Honor, is Mr. Landis going to offer that exhibit into evidence?
Yes, of course.
Okay, thank
We
you.
object. The affidavit is hearsay. It contains hearsay. It is hearsay within hearsay. So we would object to the introduction of the affidavit. Depending on the court's ruling, I may have some questions for Mr. Nell.
Okay, well, your objection is overruled. It's minutes.
Anything you'd like to ask at this point?
Mr. Knoll, your affidavit refers to a conversation you had with one of the jurors in the previous trial. Is that correct?
Which part are you talking about?
You said at least, thank you, that's a good clarification. At least 7 to 8 jurors expressed to me that they were afraid that the pool video camera may have filmed them when the camera operator attempted to focus on attorneys in the case.
Yes.
Do you remember anything else about that conversation?
No, I do not.
What were the names of the 7 or 8 jurors?
I honestly don't know names. I don't know what they look like. It was 7 months ago. I have dealt with other juries since then. It's been 7 months.
These statements were made to you outside of the court proceeding, correct?
In the jury room, yes.
These statements were made at a time when these jurors were not under oath, is that correct?
When they were not under oath.
These jurors were not under oath when they uttered these statements to you,
no, they were
correct?
not. No, they were not.
You are testifying to this today to prove that the point, apparently, that these jurors were afraid about being photographed, correct?
Yes.
So the purpose of this statement is to prove the statement, is that correct?
Yes.
And it was made out of court, correct?
Yes.
Renew my objection on hearsay, Your Honor.
Okay. It's going to, you're still overruled.
With respect to item B, the juror view of the scene, several jurors expressed concern about walking at the scene because they might be photographed or recorded on video. Do you remember anything else about that conversation?
No, I don't.
The juror, you do not remember the names of the jurors?
I don't remember if it was male or female.
Those jurors at that point were outside of the courtroom, obviously, correct?
Yes.
Those jurors were not under oath when they made those statements to you, correct?
Correct.
You are testifying to those statements to prove the content of that statement, correct?
Yes.
Renew my objection on hearsay, Your Honor.
It's overruled.
At section C of the affidavit, Mr. Noel, you say here that one juror expressed concern they might be photographed or recorded while in the transport van, and pointed to a media camera that was pointed at the front window of the van. Do you remember the name of the juror that made this statement to you?
No, I don't.
Do you remember the gender of that juror who made that statement to you?
No, I don't.
Do you remember anything else about that conversation?
No, I do not.
At the time that statement was made, it was outside of the courtroom, correct?
Yes.
At the time that statement was made, that juror was not under oath, correct?
Correct.
You are testifying to that statement to prove the truth of that statement, are you not?
Objection, Your Honor.
Okay.
The purpose of the evidence is not within the province of the witness to say, so I object to the question.
Okay, sustained.
On subsection D here of your affidavit, one juror expressed concern and pointed out to me that a media representative was on the front porch, suggested she might be taking a video recording or photographing of the jurors. What was the name of the juror that made that statement to you?
Do not know.
Do you remember the gender of that statement? Or that juror, excuse me.
No, I do not.
That statement was made outside of the courtroom, correct?
Yes.
That juror was not under oath at the time it was made, right?
Correct.
Why did you include that statement in your affidavit?
Because at the time, that's what happened.
What was the purpose of submitting the affidavit as you understood it?
You're asking him to give you a legal conclusion. He doesn't know, he cannot give you a legal conclusion. He's not an attorney.
Do you have an understanding of the purpose for submitting the affidavit?
All I was asked was to write the concerns of the jurors.
Who asked you that?
Judge Megan Shanahan.
Did she say why she wanted you to do that?
Yes, Your Honor, based upon the judicial process privilege.
Sustained.
Subsection E, after the conclusion of the trial proceedings for the day, one juror expressed concern there were media representatives sitting next to the jury box with a laptop computer. The juror indicated concern that the laptop could be used to photograph the jurors. Do you remember the name of the juror that made that comment?
No, I do not.
Do you remember any identifying information about that juror?
I couldn't tell you if it was male or female.
Do you remember anything else about that conversation?
No, like I said, it's been 7 months. I've dealt with other juries since then. I don't recall male, female, anything.
Okay. My questions are my questions. Could you answer them and not go on, please? Was there any, that comment was made outside of the courtroom, correct?
Yes,
And that juror was not under oath, correct?
correct.
What was the purpose of you including this statement in your affidavit?
Because that was what was addressed to me at the time.
By Judge Shanahan?
No, by a juror.
But Judge Shanahan asked you to draft the affidavit, correct?
Correct, but a juror is the one that told me about the laptop, the concern about the laptop.
I understand. A juror whose name you don't know, whose gender you don't know, whose other identifying features you don't know.
Correct.
On November, subsection F, on November 2nd, a juror asked, 2016, a juror asked whether I was monitoring, whether you, that's you, correct?
Yes.
Was monitoring the live stream to ensure that no jurors were being filmed. Do you remember the name of that juror?
No.
Do you remember anything else about that conversation?
No, I do not.
Was that comment made outside of the court proceeding?
Yes.
Was that juror under oath at the time? I'm sorry?
No.
What was the purpose of you including that comment in your affidavit?
Because that's what the juror questioned me.
And you were asked to, and again, this affidavit was prepared pursuant to Judge Shanahan's request, correct?
Yes.
Okay. In item 4, I'm going to jump to the second sentence. It just says specifically, one juror asked whether the checks issued to each juror for their juror pay were public records that could be released. The same juror asked whether work statements provided by the juror commissioner's officer were public records that could be released. At the time that statement was made, that was outside of court, correct?
Yes.
That juror was not under oath, correct?
Correct.
And I take it you don't remember that juror's name or any other identifying information?
No, I do not.
I take it you remember nothing else about that conversation?
No.
With respect to the jurors that you are testifying about that are the subject of your affidavit, to the best of your knowledge, are any of those jurors part of the pool for this trial?
I have no idea.
And then the last item of your affidavit, one juror asked in the presence of all the other jurors whether their completed juror questionnaires would be released. The juror expressed concerns that there was personal information that they did not want released. Was that statement made outside of the courtroom?
Yes.
That juror was not under oath at the time, correct?
Correct.
I take it you don't know that juror's name or any other identifying information?
No, I do not.
And I take it you don't remember anything else about that conversation?
No.
And I take it you don't know if that juror has anything to do with this trial at all?
Not the slightest clue.
And you included that information in the affidavit, again, at the request of Judge Shanahan, correct?
Correct.
I have no other questions.
Okay, Ms. Diaz?
And I'd ask you to,
Can you combine it so we don't have to go with you?
I just have a few.
Okay.
Maybe 2 or 3 questions. Yes, Mr. Knoll, have you spoken to any of the prospective jurors in this case?
No.
With regards to the jurors that you mentioned in your affidavit, do you have any idea how we can verify the truth or accuracy of what you're saying without knowing the names of the jurors?
No, I do not.
So we just have to take your word for it. Is that correct?
Yes.
Okay, Mr. Landis, anything else on redirect?
Briefly, Your Honor.
Okay, go ahead.
Thank you. Mr. Newell, before or since, have you ever seen a jury that's afraid to do its job?
Objection, Your Honor.
No, I have not.
Have you had other murder cases?
Yes, 2 weeks prior to this case, we had a capital murder case, and we had 1 or 2 other murder cases in 2016.
And did you have the same kind of concerns expressed by jurors in those cases?
Objection, Your Honor. It's irrelevant, and we ask for hearsay.
Overruled.
And objection, there's no foundation for it. We don't know what those other jurors were asked in their questionnaire.
Okay, overruled. Okay.
What was the question? I'm sorry.
I don't remember.
Your other, the other murder trials that were in Judge Shanahan's room.
I was asking you about other murder trials and whether they had been that afraid to do their job, and had they expressed to you these similar concerns in those other murder cases?
No, they did not.
Thank you. That completes my examination.
Thank you.
I don't know if the defense or prosecution wish to participate.
I see Mr. Matthews, and I know Mr., there he is, I see him. Mr. Teeger, anything from the state of Ohio for this witness?
No, Your Honor, thank you.
Okay, thank you. Mr. Matthews, anything from the defendant?
No, Your Honor.
Thank you. Mr. Knoll, thank you. You may step down. I want to make note of one thing here based on that testimony. I am taking judicial notice at this point of the fact that in Judge Shanahan's case as well as in the case at hand, no jurors' names are known to anyone besides the judge and the attorneys for the parties. The jurors are known only by numbers. They wear numbers on a placard around their neck, and that is how they are referred to during court. And additionally, the only communication between judges and jurors in any trial, and in particular these 2 trials because these are the ones that we were talking about, the only communication between jurors and the judges runs through the bailiff, which means you're going to have a number of times when jurors express issues to the bailiff that they have so that those issues may be clarified or taken care of by the judge. All right, Mr. Landis, your next witness.
We call Emily Rose.
Thank you.
Would you please walk this way and walk toward the witness box, and the friendly bailiff will take care of you.
Would you solemnly swear that the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth, so help you God?
Ms. Rose. There you go.
Would you please state your name?
Emily Rose.
What's your position?
I'm a deputy sheriff with the Hamilton County Sheriff's Office assigned to the Court Service Division.
What's that mean, court service?
Court Service Division is responsible for primarily running inmates to court, ensuring the security of the building, and the integrity of all court proceedings in common pleas courts. I'm specifically assigned to a surveillance intelligence and investigations unit that monitors activity around the courthouse and in the courtrooms.
Thank you. How long have you been doing that?
2 years.
How long has that unit been up and running?
2 years.
What did you do before that?
I was a court service deputy involved in the standard duties of the position.
How long have you been involved in security in the courthouse?
2.5 years.
Thank you. Is it part of your duty to monitor security footage at the courthouse?
Yes, it is.
After the beginning of the Tensing trial during voir dire on May 30th, did you have the opportunity to review video footage of anything different or unusual?
Yes, during the first part of the day when everyone is initially coming into the courthouse, we observed a couple individuals videotaping.
Your Honor, objection.
What's your objection?
Best evidence rule. If this is on video.
Pardon me, I'm sorry.
Best evidence rule, Your Honor. If she's testifying what's on video footage, let's see the video footage.
We have, are the photos being submitted, Mr. Landis?
I believe best evidence deals with whether or not you're dealing with the contract, not with video.
It deals with documents, which includes video. She cannot stand up here and testify about a document when the document's available. The best evidence is the footage. Let's see the footage, please.
If I may be heard, Your Honor.
Yes, you may.
I understand brother counsel's objection, and our response would be that that because the court is trying to determine exactly what it's trying to determine today, that her account of the video is sufficient. And if we need to get into additional facts about why that's a better choice, we can do that. But for now, anyway, my question stands, and I would propose that at this point, the objection be overruled.
Your Honor, how do we effectively cross-examine this witness? If she says what's on there and we can't see it, she can say whatever, and we have absolutely no basis. So that's exactly why the best
You're
evidence
implying
is
she's lying under.
I am not implying anything, Your Honor, other than I have the right to effectively cross-examine a witness. And if she is testifying to video footage that is available, we have the right to see it so that we can effectively cross-examine the witness. Thank you.
Overruled. Go ahead.
I was asking you what you observed as part of your duties in security on May 30th after the voir dire had begun in State versus Tensing.
I observed 2 individuals at separate times videotaping the front of the courthouse, and specifically the individuals in line trying to get into the courthouse.
Is that a typical day for your courthouse?
The lines themselves, I would say, are typical, particularly after a holiday weekend. There's nothing unusual in that, but there is an unusual trait in the fact that he was videotaping the lines.
How could we tell that he was doing that?
Frequently, over the last couple of years, we have observed multiple individuals taking pictures of the courthouse. It's a historic building, but you can tell based on where the camera's aiming that it's either taking pictures of the writing at the top or something higher than ground level. This person spent several minutes videotaping at ground level, panning back and forth, and also changed positions twice to get both sides of the lines and went across the street, always maintaining that ground level view.
Not pointing up at the facade?
Never.
About what time of day did that occur?
The first instance was at 8:49 in the morning, and the second was at 9:33.
Was it both the same person?
No, they were 2 separate individuals.
Okay. And at those times of day, are there jurors in the line?
Usually there would be, though there's no way to know for sure.
Okay. They get in the same line as everybody else?
They do.
And they try to get in by a certain time, but there's a line?
Yes. Correct.
Okay. Well, in the years that you've been on security, and particularly the last 2 years when you've specialized in this particular kind of investigation, have you ever viewed anything like this behavior?
I have not.
This completes my examination of this witness, Your Honor.
Thank you, Mr. Landis. Mr. Griner, order Ms. Diaz.
Thank you, Mr. Did you said there were 2 separate individuals taping?
There were.
Did you speak to those people?
I did not.
So you have, okay. Do you know of anybody who spoke to them and asked what they were doing or why?
I am not aware of anyone.
Thank you.
Okay, oh, I'm sorry, Ms. Diaz.
Do you agree that the courthouse steps and the area outside the courthouse is a public place?
I would.
And that anybody can take a picture of anything out there?
That's true.
Was there any reason to believe that? Oh, that's it. Thank you.
Thank you. Anything else, Mr. Landis?
No, Your Honor.
Okay, thank you.
You may step down, Ms. Rook.
Thank you. Mr. Landis, your next witness.
Thank you. We call Sergeant Dreyer. I hope he's loaded up right here. And there he is, as if by magic. Sergeant Dreyer, would you drop for the bail up there and swear you in?
You do solemnly swear that the testimony you're about to give before this court will be the truth, the whole truth, nothing but the truth, so help you God.
Would you state your name for the record, please?
Michael Dreyer, D-R-E-Y-E-R.
What's your position here in this building?
I actually do not work in this building. I work out of 800 Broadway. I'm
Okay.
in charge of the electronic monitoring unit. I have been brought up to this building for the State of Ohio versus Ray Tenzing trial, the first one in 2006, and now in 2007, to assist Lieutenant Brogan and Sergeant Dale Whitmer with the overseeing of the trial.
I have the same issue. I've gone through many decades, and sometimes I skip ones. Do you mean 2016 and 2017?
Correct.
Thank you. Are you alone, or are there a bunch of you guys that have been detailed for this special reason?
Sergeant Whitmer and I were both brought from other buildings to assist. The main sergeant in this building still has to do his day-to-day operations. We have 16, 18 other common police courtrooms that we have to attend to other than Judge Gibbs.
Okay. Why you? Do you have any special training in this line of work?
I was sent to Nevada with a few other officers to attend a court security, week-long court security training and seminar.
What did that focus on?
Protection of the judges, protection of witnesses, jurors, transportation of judges for high-profile cases, transportation of jurors, high-profile cases.
Thank you. Would you turn in your exhibit book in front of you to Exhibit A as an alpha? And you'll see an entry from the court dated May 18. I'd like to draw your attention to the third page. Under the word ancillary areas. Have you looked at this particular?
Yes, I have seen this document.
Is it part of your job to enforce this?
Absolutely, yes.
What I'd like to do is ask you something about that. I'd like to ask you, first of all, what risk does this particular order aim to reduce or take care of?
I believe this order, the Sheriff's Department has to utilize a lot of people currently.
I'm going to object. That's your order. I don't believe that he's qualified to testify. If we want to understand the risk that this order is aimed to address, I think maybe you should tell us, Judge, but I don't think the witness is qualified. And it calls for a legal conclusion, and much like the objection that was raised with us previously.
I appreciate it. Any response to that, Mr. Landis? It's overruled. I'll tell you why. Because this portion was put in at the request of the Sheriff's Department based on their safety concerns, things I had no idea were even issues until they brought it to my attention. Go ahead.
Thank you. What kind of risk does this attempt to address?
We are utilizing people from the Corrections Division, the Enforcement Division, and also our own people in the Court Service Division. This order gives a statement that there's no electronics allowed on the 5th floor. Corrections officers don't know who the media is, who the general public is. A lot of times they might not know who judges or attorneys are. And that would go for the enforcement officers also. And with this order, they don't have to question people. Everyone can go about their day-to-day activities, and they can just simply tell them there are no electronic devices allowed on the 5th floor.
How do you get that information to someone coming up on the 5th floor?
We have added additional officers to our complement. We have stationed them in all 4 corners of the courthouse and in the middle stairwell where there's another stairwell and elevator. As soon as the people would come off the elevator through the stairwell, they'd be advised that they need to turn their electronic devices off.
What kinds of things happen in the courthouse hallways that you guys worry about?
Our concern would be for the jurors, for witnesses. There's been
Objection, Your Honor. Last presentation. She can read that.
Okay. No, it's overruled. He can talk about what happens up here on a day-to-day basis. Go ahead.
Those would be our main concerns.
Okay. You mentioned both jurors and witnesses.
Yes.
Have you had instances where handheld devices were used as part of that concern, part of that issue?
Yes, pictures have been taken of both witnesses, jurors.
You were involved in the first trial of State versus Tensing.
Yes.
Did you try less restrictive means than what we have on the page in front of us to take care of this risk?
There were less restrictive means. It was slightly easier in Judge Shanahan's courtroom because where her courtroom is positioned. In this courtroom, we have to worry about Judge Cooper's day-to-day docket, Judge Kubicki's, Judge Luber's. So Judge Giz's courtroom makes it slightly more difficult for us.
Okay. What about this particular restriction makes sense for you in the way that you want to administer this? Why this restriction? Why is this necessary?
I believe that this court order will protect not only the jurors, the witnesses, the general public. It will make the jurors more at ease to know that their identity is concealed and people will not know who they are. I believe it'll help them do the job better.
Thank you. This completes my examination of this witness.
Thank you, Mr. Landis. Mr. Greiner or Ms. Diaz, whoever wants to go.
Mr. Dreyer, did I understand you to say that that pursuant to this order, you didn't draft this order, by the way, did you? I'm sorry?
No, sir.
Okay. Who did?
Judge Giz.
Okay. Who provided this information to Judge Giz from your office?
I do not know the answer.
But not you.
I gave input, but I did not provide it to Judge Giz.
Did I understand you to say that no one is permitted to use electronic devices on the 5th floor pursuant to this order?
Attorneys would be allowed to use it in the the 3 corners. But if I remember correctly, it restricted almost everyone.
And attorneys are able to show you a card to identify themselves as attorneys?
Yes, a practicing attorney would have an attorney ID issued through Hamilton County. And they would be able to show that to an officer in one of the corners.
You're aware that the local media have press credentials, are you not?
Through Hamilton County, issued through the Hamilton County Sheriff's Office.
They have identification that clearly identifies them as members of the media. You're aware of that, right? I don't think it's issued by the Hamilton County
Issued
Sheriff.
by their own company. I don't know, yes or no.
You don't know.
No, sir.
So if I were to tell you that the media does, and that they would very easily be able to identify themselves as members of the media if asked, you'd have no way to dispute that.
No, I would take you at your word.
Thank you. No further questions.
Ms. Diaz?
You said that, I just want some clarification on one of your statements. You said that pictures have been taken of both witnesses and jurors. Are you talking about other trials? What trial are you talking about there?
They have been, it's been in numerous past trials. I recall from the Raymond Tensing trial in 2016, local media outlet filmed one of the jurors. But I believe we did everything we could to protect the jurors at that time.
But that was the inadvertent filming that Judge Giz's order talked about before, is that correct?
That's correct. I believe it was inadvertent, but it did happen.
You mentioned that in the 2016 trial that it was easier to do different things in Judge Shanahan's courtroom because
Correct.
of the way it's set up.
Correct.
Wouldn't the least restrictive means here be to move this trial to Judge Shanahan's courtroom?
I wouldn't be at liberty to make that decision.
Why not?
Judge
Uh,
Hayes' case.
I'll interject. I don't care if you're asking the witness. These are our courtrooms. I can't go to a judge and say, hey, by the way, get out of your room for 3 weeks so I can handle a trial in here. It doesn't work like that. This is my courtroom, and this is where it will be conducted, with the exception of a few hearings that may be in another room. But otherwise, it's going to be conducted in my courtroom, and the sheriff's office has no say whatsoever over where the trial is held.
I have nothing further. Thank you.
Anything further, Mr. Lewis?
No, Your Honor.
Okay, you may step down. Thank you.
Your Honor, this completes the witnesses that
Okay.
we prepared for the court. I do have,
Oh, you know what I did? I apologize. Mr. Teeter, is there anything you'd like to ask of either Officer Rose or Sergeant Dreyer? And if there is, I will have them call back. I apologize. Mr. Teeter?
No, Your Honor. Thank you.
Okay. Mr. Matthews?
I don't have any questions, Jeff.
For either witness?
Correct.
Thank you. Okay, go ahead, Mr. Lynn.
We have 3 items in the exhibit book for
Okay.
which we ask judicial notice. First of all, the contents of Exhibit C regarding a prior jury tampering that you mentioned in your opening remarks concerning using a handheld device during voir dire in this courtroom. The contents of Exhibit D showing the prior news coverage, you mentioned the current news coverage already, and the contents of Exhibit E, which were prior filings in State versus Tensing, including the mentions of accounts of jurors being near tears when asked to go back into the courtroom after learning that the media had asked for their unredacted jury questionnaires.
Your Honor, first of all, let's clear the record for what these items are. Exhibit C is an affidavit of Greg Ventry. It's my understanding he is a Hamilton County detective, presumably a Hamilton County resident. Exhibit D is an affidavit of Julie Wilson, who works for the Hamilton County Prosecutor's Office, presumably a Hamilton County resident. I see her at the gym I go to, so I'm pretty sure she's a Hamilton County resident. And Exhibit E is an affidavit of Christian Schaefer, who's with the Hamilton County Prosecutor's Office. These affidavits are hearsay. They're out-of-court statements introduced to prove the truth, and they are from witnesses who are easily subject to examination in this proceeding. We absolutely object, Your Honor, and they have no basis for introduction here, as they are textbook hearsay. For that reason, Ms. Diaz and I object.
Okay.
yes, the facts contained in these exhibits are in fact already known to the court. The jury tampering occurred in this court, with this courtroom. The press on Tensing was available to everyone. And the record in State versus Tensing is now your record, because this is now your case. So while there are affidavits atop each one of these facts, the facts are what we're asking you to take judicial notice of. If there is something in particular that counsel has a concern about a fact that might be adduced by calling authenticated what was already in the record, be willing to talk about stipulations, so long as brother counsel who are in the case would also. That would not be served merely by taking judicial notice of these facts.
These exhibits. Mr. Reiner, any witnesses you would like to call?
Your Honor, if we could get a stipulation, I may not have to call a witness. If we can't get a stipulation, I may have to call Mr. Matthews. The stipulation that I would like would be a stipulation that Mr. Tensing, the defendant in the case, has access to and permission to view the unredacted question.
I don't know that it's true, but if other people in the courtroom believe it to be true.
Mr. Matthews, that's correct, isn't it? Or no?
Is what correct, Jeff?
He's able to view at the table with you the unredacted questionnaire.
Yes, he is assisting me with jury
With his defense. Okay, thank you. Yeah, we'll stipulate to that.
Thank you, Your Honor. I do not have witnesses. I would have some questions of the court that I would like to pose with the court's indulgence, but I can pass.
Go ahead.
Your Honor, it is not clear to me, and so this is why I'm asking respectfully the question. The First Amendment, as applied by State XRL Beacon Journal versus Bond, Superintendent's Rule 45, and Rule 12 pursuant to State XRL Scripps Media versus Hunter, which is a First District case, all require a court to make on-the-record findings based on evidence, and Rule 45 expressly says clear and convincing evidence, that the restriction is required by, and the words vary a little bit, but an overriding concern to preserve a higher interest. And I would like to ask the court, because it is the court's because the court is required to do so, to tell us what is the higher interest that the court feels identifies, or the court feels requires a restriction on the judicial access here.
I apologize, but I just sat through about an hour of testimony about the different issues that are of cause of concern to this court. I am taking all of this under advisement in light of any objections that you and Ms. Diaz may present to this court, and then I will give you a written opinion or a written entry later today, hopefully later today. But that is precisely why we are having this hearing today, is the concerns, or are the concerns that I personally have as the judge presiding over this case, as well as concerns that the jurors have expressed in the new case, in the Tensing 2 case, as well as the concerns that were expressed by jurors in the Tensing 1 case, as well as the concerns that were expressed by the Sheriff's Office based on the location of my office and what is best serves protection of everybody involved. But I will give you a written order later, at a later time, very soon. But that is the precise reason we have this hearing today.
Thank you.
Anything, Ms. Diaz?
To the extent that the higher interest that you're citing here is based on the questionnaires that we haven't seen, I object, because we cannot, the jurors who are concerned are not before us today to be questioned under oath. We don't know what their concerns are. If their concerns are just general concerns, it doesn't meet the standard under a lot of case law that we've all cited back and forth, but including the Blagojevich case. I would ask you to look at that. If the higher interest is some jurors are concerned, we don't even know what their precise concerns are. How can we make a particularized finding about matters of deep personal interest when we can't even ask the jurors what those are?
Ms. Diaz, what I have found with the media counsel in this particular case, I've never faced it before, is that, you may have a seat, is that counsel continues to go back to the fact that they can't question these jurors, therefore, how do they know? But that's the whole crux of what is going on, is the fact that jurors are scared. I spelled out a question. You all have the jury questionnaire. It's blank, but it tells you what the questions say. Question number 104 and question number 150. 104 speaks to if their identities, and this is not the identical wording of that question, but it essentially says the media is going to ask for your identities, or has, or something to that effect. If we have to release them, if the court is required to release those, are you still willing to sit as a juror in this case? That's number 104. Number 150 says, if you do you have personal safety concerns, and this is just another paraphrasing of that question. Of being a juror in this manner, and ask them to expound on what their safety concerns are. I have read those in camera. I went through 180 questionnaires, and I gave you the numbers earlier in this hearing as to how many people are seriously concerned about that, and they are seriously concerned about their safety if their identities are released. No decision has been made on jury questionnaires, and you will not see a decision on that for a few days. The number one issue we have right now is media coverage, actual electronic devices and filming of the media, or of the proceedings by the media. That's what will be addressed immediately, and then forthcoming will be the issue with regard to the jury questionnaires.
Your Honor, if I may ask, when does the court believe it will begin the voir dire?
Tomorrow morning.
So I think what I'm hearing from you, and I'm asking this for a point of clarification, you do not intend to rule on the request for the questionnaires before voir dire begins. Is that correct?
I am not certain what I will be doing. But I know the first issue at hand will be media coverage.
Your Honor, there's no, I'm sorry, I didn't mean to interrupt.
By all means, go ahead, Mr. Greiner.
I'm sorry if I didn't.
No, go ahead.
There is no way for the press or the public to meaningfully participate in the voir dire process, which is their First Amendment right to do, without, at a minimum, the redacted questionnaires. At a minimum. There's simply no way for this court to understand, for the press and the public to understand who is sitting in that box. And so we need, Your Honor, some decision so that hopefully the questionnaires will be released, or at least we can go back to the First District Court of Appeals and ask for them to intervene once again. But there is simply no way that the press or the public can have any meaningful involvement when the questions are essentially answered in documents that the press and the public cannot see. The last time in the last proceeding, in my recollection, voir dire took about an hour. People were astounded by that. The reason it did was because all the information was in the questionnaires. So I think with voir dire beginning tomorrow, and if those questionnaires, at least in redacted form, are not produced, the press and the public will have no way to know much of anything about the jury that is presiding over this case, which, as you said, is of great public interest. That will not engender trust in the fairness and the integrity of this proceeding, and will do, quite honestly, the opposite. So we would urge you, Your Honor, to provide the questionnaires at a minimum in redacted form. We think they should be provided in unredacted form, but at a minimum in redacted form, or at least indicate that you choose not to do so that we can ask the First District Court of Appeals to intervene in a timely and meaningful fashion. But if there is delay, that will simply result in a situation that is really untenable.
Okay, thank you. Anything further? No?
No, Your Honor.
All right, the issues will be taken under submission. I do want to make it clear, if I have not already made it clear in the record, that I'm taking judicial notice in this case, and that this case is the character and a nature that in the community that incites passion regardless of the outcome it has, and that needs to be noted. A decision will follow promptly. Thank you.